Okay, it's a real pleasure to be here, and I hope we can have an informal discussion. Let me just make a few preliminary remarks. First, let me say these are really important negotiations that you're going through, and particularly those of you who are involved in the discussions of the intellectual property rights, and particularly the intellectual property rights that affect the health sector. I can't tell you how important these issues are. They sometimes sound like just words that you craft and you negotiate this word versus that word, and you can argue all night about a few words. But unlike most things in trade agreements, if it comes out one way or another, the price of some commodity may go up, profits of company may go up a little bit, some profits of some other company may go down a little bit. What you negotiate here involves the lives of people. And when you think about lives, we're talking about literally thousands and thousands of people who will die, and thousands of people who will have a different quality of life as a result of what you decide in the next couple of days. I just want to also emphasize, it's not just you can get a report of how many people will die, and those are statistics, but you need to translate that into people. That it will affect maybe not in your family, but in somebody else's family. Somebody will die as a result of what you do or do not do in this agreement, or their lifestyle will be affected significantly. So this is a big deal. It's one of the reasons why, and there are many complex issues, and I'll come back in a second to what to try to simplify this into what it's really about. But take one issue that is under discussion is what can be patented. What are the things that can be patented? That issue is an issue that is debated in every country, and the answers sometimes come out differently. But it's important that a trade negotiator not necessarily solve this problem for today and for all time going forward. And the view of the United States at one moment may not be the right view even for the United States. So let me just give you one example, one that I feel that I got very involved in. Many of you may know that a suit was brought about whether you could patent genes. And the patent office in the United States had granted a patent on a gene. And it happened to be a set of very important genes, because if you have these two genes that are called BRCA1, the BRCA genes, the probability that you got breast cancer was over 70%. So knowing whether somebody had this gene was a matter of life and death. You could take precautionary actions, you could monitor them. And Yale University developed a test for this gene, and there were people in the United States who were willing to fund to make sure that everybody who wanted the test could get it. But the owner of the gene said no. They said you could only use their test, and you had to pay $5,000. And of course, if you're poor, you can't afford $5,000 just for a test. Well, as you get old, you think about what will, when you meet your maker, what will you think is important in your life? And proving a theorem, proving some mathematical ideas to get you a Nobel Prize is important. But I think among the things that I'm most proud about is my involvement in that particular suit. because I joined the American Civil Liberties Union that said that gene, that patent violated the Constitution, violated people's basic right to live. And what is an economist involved in that? Well, there are economic issues involved in almost everything. And in this particular case, the issue was, does that patent promote innovation? Was there more innovation as a result of the patent or without the patent? So it was a narrow issue, but an economic issue. And I wrote an affidavit to the court saying these patents were actually destroying innovation. And we actually had strong empirical support for that conclusion. And I'm pleased to say, say things that you're proud of in your life, is the Supreme Court sided with me and the American Civil Liberties Union. And as a result of that, people will not be dying who otherwise would be. We documented that people who had died because of this patent. And then we reversed that, and now people who otherwise would die are not. So this is, maybe a dramatic illustration, but I want to bring home the fact that what you are doing is not just words. It goes beyond that. It goes to people's lives. Well, then the question is, what is this about? What are all these complicated provisions like linkage, and you're much more into these issues than I am, although I've followed them for a number of years. What are all these data exclusivity? What are all these provisions about? Well, from an economic point of view, they're about two things. They're about restricting competition from generics. Basically, when a patent expires, generics come in, prices go down, and if you're the owner of the patent, it's just simple economics, you want to keep out the competition. And this is true in every business. We teach in the business school, and I teach in the business school, and competitive markets aren't very fun. Competition drives prices down. You have to work hard. You have to, it's much better to be in a monopoly. And so I'm perfectly sympathetic with that view, except that's not the way markets are supposed to work. And it doesn't lead to an efficient economy. It doesn't lead to a dynamic economy. It doesn't lead to an economy where citizens do well. So this is first about delaying the entry of generics. It's not to stop it completely, but to delay it. And in that delay, profits go to the original owner of the patent, and prices are higher. And there are a whole set of techniques that, when we're teaching it from the point of view of the business school, we try to teach the students how to do this, how to maintain monopoly power. I feel a little guilty about that, but at least then, they understand the game. But there's a second part of this. So one is to restrict competition from generics. When there's limited competition in any industry that's important, governments engage in regulation. So if you have a natural monopoly like gas, electricity, you have regulation to try to keep the prices down, because the natural thing of a monopolist is to charge monopoly prices. And that leads to inefficiencies and distortions in the economy and other consequences. And in this case, the consequences are serious, people dying. So that's the second thing that is, from what I could hear, is being negotiated. What is the extent of the use of regulatory devices to circumscribe the monopoly power of the patent owners? So to try to create a more, you can't create competition, but a more competitive environment. So an example, in several countries, and some of them here, you had formularies that said, here are a list of drugs that have that have benefits that are worth the cost, or that are better than other drugs that are similar. So that's a way of getting a limited form of competition, because people want to be on that formulary. Now, the drug companies, the big pharma as we call it, don't like that. And again, for obvious reasons. Nothing wrong with that, but except it is something wrong. That leads to higher prices. In the United States, the worst case, they succeeded in getting a bill passed when we passed our Medicare extension that said that the US government could not negotiate any drug prices. And the cost of that one provision was estimated by been estimated by various people at over $1 trillion over 10 years. So that's the second point I wanted to raise. This is mostly about lives in my mind. This is mostly a moral issue, and it's a very deeply moral issue. But it's also about budgets. And it's about budgets in all our countries. I don't think any of our countries are facing a budget surplus. And so if you have to spend more for drugs, you have less to spend on other things. I mean, it's just simple arithmetic. And in particular, if you have your health budget, if you have to pay more for the drugs, you have less to pay for other health initiatives. And if you look at it from the budget of the whole country, a country like Vietnam, if they have to spend more on drugs, they have less money to spend on development of, other development initiatives that they have. So the question is, what is the best way of spending that money? And in general, the view is not on excessively high drug prices. So let me make clear, this is not about the issue about whether there should be intellectual property rights. That's not an issue in debate. I don't think anybody is arguing about that. It's trying to get the balance in, and that's the whole thing about any intellectual property regime. And every country is engaged, or should be engaged, in a debate about what is the intellectual property regime. How do you balance the dissemination of ideas, the access to medicines, with incentives for innovation? But the intellectual property regime has to be seen within the broader context of the country's innovation system. And it's only one part. And so you're trying to get a balanced innovation system, and within that, a balanced intellectual property regime. In the United States, we try to get that balance with respect to generics back in the Hatch-Waxman Act in 1984. And it's interesting, the result of that is that generics have grown from 13% to, I think, about 86% of the market. And that's brought down prices a lot. It brought prices down a lot in two ways. One, the fact that the generics themselves are cheaper. And the second one is the competition of the generics has an effect on prices of the non-generics. There's a constant battle going on to try to change that balance. The drug companies would like to put more restrictions. The drug companies have engaged in anti-competitive actions that have been challenged in the courts of trying to bribe the generics not to enter. So the range of creativity, of how do you reduce competition, is a testimony to the quality of our business schools, and the innovativeness of American businessmen. But it isn't necessarily serving our society well. The problem is now that in the trade agreement, they're trying to lock down a particular set of provisions in a very dynamic industry, and that, I think, would be a mistake. So I think it's absolutely imperative to maintain the right balance and also to maintain flexibility going forward. And this is true for all of you. It's also true of the United States. I mean, just take one issue in the United States where the U.S. government, I should say the USTR, from what I could gather, is taking a position that's the opposite of what the Office of Management and Budget has taken. The Office of Management and Budget has said that on biologics, data exclusivity, no justification of 12 years. And they want to bring it down to, I think it's 7. But this agreement, the USTR, typically doesn't pay attention to a lot of the scientific evidence, doesn't pay attention to economic evidence, is trying to lock in for the United States, as well as for other countries, 12 years. So what is going on here, I mean, to put it in the context of America politics, which I know a lot more, what is going on here is an attempt to in-run our democratic political process, to try to do through a trade agreement what they couldn't do in Congress in an open discussion. And that's why they want part of the reason they want fast track. They don't want to, if they had an open discussion in Congress, these issues would be aired and there'd be a lot of opposition from health groups, from academics, from the National Science Foundation, National Academy of Science. I've been fighting these issues for 20 years. When they first raised the intellectual property in a trade agreement in the Uruguay round, I was on the Council of Economic Advisors, and I was the one who was responsible for the trade issues and intellectual property. And both the Council of Economic Advisors and the Office of Science and Technology Policy in the White House opposed the TRIPS agreement as it was formulated. But the USTR, which was accountable, you might say, to the producer interest. Remember, the head of the USTR was the campaign manager. I'll be a little bit blunt about all this. He was the campaign manager, and in the process of campaign, you get decks, and you have to pay back those decks, and that was what a part was going on. And so it was, the intellectual property provision did not reflect the scientific community, not the economic. It reflected the interest of the entertainment industries and the drug industry. And it was really that simple. Well, if the battle at the Supreme Court was one of my victories, this was one of my defeats, because TRIPS, you all know about, was adopted. After that, I was in an international commission, it's called the International Commission on the Social Dimension of Globalization, where we brought together experts, leading people in the private sector from around the world, private sector, government, academics, civil society. And the consensus, you can get the report of that commission, was that one of the ways that globalization was going awry, was not working well, was on intellectual property. And what we said is we needed TRIPS minus. And what the USTR is pushing here is TRIPS plus, 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 plus. And so I think this is, an issue that's been before the international community now for 20 years, and unfortunately is continuing to go in the wrong direction. The reason I mentioned before that the OMB was concerned about the 12-year data exclusivity versus 7-year, moving it down because there was no justification, was it has budget consequences. That it leads to higher prices, and OMB's job is not, they're not health experts, but they had to judge the health evidence, and they said the budgetary consequences were enormous compared to any benefits that could be achieved. Well, I want to dispense with 3 issues that come up repeatedly. One of them is This agreement, these provisions are about employment. That's not true. In fact, net, they'll probably go the other way. How do you generate jobs? By selling more. How do you sell more? Lower prices. And this is about higher prices. So this is not about jobs. Not jobs in your country, not jobs in the United States. Where jobs get located is not about so much about intellectual property. It's about a whole set of other competitive factors, both on the research side and on the production side. You know, production in the United States moved to Puerto Rico. Did it move to Puerto Rico because drugs are produced in sunshine better? Singapore is another place where they produce drugs, but it wasn't the sunshine that moves them. It's an other set of tax benefits or something else that drives that. And research is moving. A lot of good research labs are now moving to China because they have the best intellectual property regime. No, they don't have the best intellectual property regime. They're moving to China because they have good scientists. And the government's willing to support good labs. That's where innovation occurs. So this is not either about the innovation, about where innovation is being located, nor about jobs. It's not about innovation in general. Most of these drugs that we're talking about today come out of I don't want to boast, but come out of a side product of universities. You know, that's where the basic research is going on. And NIH, government-supported labs in most countries. So that's where the drugs are coming from. But as I pointed out in the research that I've done, evidence, the patent system, as an unbalanced patent system, which we're moving towards, stifles innovation, stifles follow-on innovation. You know, we're talking about drugs, but in other areas, even people in Silicon Valley, which is the center of the innovation in the United States, have said our intellectual property regime is stifling innovation. And the National Academy of Science, you know, there's just a broad consensus that we haven't quite got it right. I'm not going to try to describe what would right be, but what I want to emphasize is the USTR doesn't know. And the USTR is trying to put into this agreement, lock in a view that represents a particular set of industries, but will not represent the well-being of innovation, science, for the coming years, decades. So you don't want to lock it in. You know, this has to be continuously renegotiated and debate. So then the other issue is, it's not about employment, not about jobs. It is about giving more profits to a particular set of industries, particular industry. The final question that people often ask is, well, how important is it, A, to join the TPP on the one hand, and secondly, what would the U.S. bargaining position, you know, what give is there in U.S. bargaining position? Now, obviously, I can't answer those questions very, very, very clearly. You're more the negotiators, and you'll have to figure this out. But I want to make just a couple observations. You know, first of all, nobody goes into a bargaining, as I said, go into a bargaining room and said, by the way, this is my position, but I'm totally willing to move away from that. That's not the way negotiations typically get done. People begin very saying, you know, I'm serious about this. And this is particularly true in America because as the USTR has been populated over the years by lawyers and litigators, not people who are experts in economics or in trade theory or trade policy. They're lawyers and litigators. And that's their life. They love to do these things, and they do it extraordinarily well in terms of doing their job of bargaining. But that doesn't necessarily mean that it reflects the views of either the U.S. government, certainly not the views of the American people. I want to make that clear, that they do not represent the views of the American people. So, say couple just observations. One is that I think President Obama wants this agreement, that he's facing a Republican Congress. There's not much he can get through, and it's important to him to have an agreement. And that gives you a lot of bargaining leverage, that I think that they would probably sign an agreement that is not necessarily the one they would have liked to have had, but is the one that you guys demand, reflecting the concerns about your country's interest. The second point, and a little bit more delicate point, but I think I should raise it anyway. Many of you, I know many of your leaders want to join the TPP because they think it will bring them into a more special relationship with the United States. And should there be problems in that part of the world, the United States will come to your assistance. And that signing an agreement will also increase the bonds with the American people. There's a grain of truth in it, but I want to make it clear that it's only a grain. So two examples. When President Bush went to war in Iraq, he tried to persuade lots of countries to send troops to Iraq. I thought it was the wrong war. President Obama said it was a stupid war. And we know it's destabilized that whole region. So I was talking to the Polish finance minister about Poland supporting the United States and sending troops, and it was very clear that he felt it was important to do that, to increase the bonds with America. And I've tried to point out to him that that war did not have the support, or would not have the support, of large fractions of the American people. And now 70% of them think it was a mistake. And so supporting the U.S. in a flawed policy is a mistake. What we remember now is that France stood up and said, and people from Sweden stood up and said, look, they don't have weapons of mass destruction. And said, we don't have the justification for going to war. We're violating international law. So the point I want to make is things are complex, and don't think that just because you are satisfying a USTR today or a U.S. administration today, it will build long-term bonds. It's about really the fundamentals that bind us together. And the second example is one, again, that's very much in the news, and that's Ukraine. We signed an agreement with Ukraine saying that if they got rid of their nuclear warheads, we would protect them against a Russian invasion. But of course we didn't. And that's just the point that they should have known, and I'm surely we knew, that at the moment we will judge what is in the interest of the United States and our politics. So you live in as many of you live in a very difficult region, and you know that there could be threats. Know that whether you sign this agreement or not will have absolutely no effect, significant effect, on what the United States does. So you have to, as you face this, think about what I would say is the moral and the economic issues. The moral issue being, what will this do to the lives of your people? And the economic issue is, will it actually help your economy in any meaningful way? Well, I know most of you are in the health issue. I just want to highlight one other set of issues in the negotiations in case you talk to your colleagues, and that's the investment agreement part of TPP. And that part has been highlighted, has received a lot of attention because we're trying to put that same kind of provision in the agreement with Europe, the transatlantic agreement. And Europe is asking the obvious question. Why, the investment provisions are supposed to be about property rights and making sure you have good property rights systems. So people in Germany and other countries in Europe are asking the question, I don't understand. We thought we had as good a property rights system as the United States. Why are we having an agreement with property rights in it unless something's wrong with our property rights? And if there's something wrong with our property rights system, shouldn't it be not just for our trading partners, but for our own citizens? Why should foreign trading partners get rights that are stronger than our own citizens? Let's get our property rights system correct, but let's do it for everybody. In fact, there isn't anything wrong with the property rights system. I don't say anything wrong, but there is nothing major wrong of the kind that is being addressed by these trade agreements. The provisions are an attempt to get around what we sometimes call regulatory takings or regulatory frameworks, where U.S. courts have consistently said that there's no compensation for regulatory takings. So the president, in the beginning of his administration, formed a panel of civil society and business community to look at this investment agreement. And civil society came out and said, this is not acceptable in the United States. And so there are strong opposition. The business community wanted it, but they've wanted a provision about regulatory takings for a long time. And administration after administration has said no, and the courts have said no. So what is being buried into these agreements are things that we would never have been able to get through our democratic processes directly if we had an open debate. Since you are involved in health, one aspect of that has gotten a lot of attention, and the USTR is trying to say we'll have a carve out, but is on smoking. As you know, under this particular provision, a similar provision in Uruguay and Australia, Philip Morris has been suing Uruguay for a regulation about smoking that the WHO says is a good regulation. And it's similar to what we have in New York City. So they're trying to undermine this. When I try to inflame audiences, I call this the USTR's new opium war. And the reason why, I don't know, some of you know that the Western powers' first trade initiative with Asia was when China said that it did not want to have opium, which the West was selling to correct the trade imbalance, because China had a lot of things that we wanted, but we didn't have anything that China wanted, so there was a trade imbalance. And we figured out a way of correcting it by selling China opium. And opium, again, is what we talk in business school, a great product, because if you have the really good products are repeat purchase. And opium has good repeat purchase properties. So, and when China said no, the West went to war with China to open up the markets. And our cigarette initiative is what I call the new opium war. So that's a provision that many of you may not be involved in, but it's part of the investment agreement provision, and it will have very big effects on health. But this investment agreement also has implications for other economic, environmental, health, safety regulations. I was just talking with a negotiator from Chile, where Chile signed investment, a bilateral trade agreement with the United States, and in their agreement there was a provision about financial market regulation that restricted the ability of Chile to respond to America's QE, which led to their exchange rate going up and killing off their export jobs. So, you know, some of us joke that no one told the USTR yet that we had a financial crisis in 2008 that most people think have to do with financial regulations. And that there's a broad consensus that we need new financial regulations, and the question is, will these provisions restrict those financial regulations? Now again, let me go back to the general point I made before, flexibility. The world is always changing, and it's hard now to say, okay, well, you might say, we'll exclude that particular regulation. You can do that, but the world is changing, and you want to have the flexibility to impose new regulations to respond to the changing environment. A new way of designing intellectual property to reflect the new world. 20 years ago, there weren't biologics. Today, there are. So you really have to have a dynamic, an agreement that has a lot of flexibility. So the final question I want to just mention, are there any compromises that one could get? And there are just two ideas I want to throw out. One, you might say, is an obvious one. I don't know why it hasn't been put on the table as seriously as it should have been, and that is to go back to the terms of the Peru Agreement, the bilateral Peru Agreement that was negotiated if those of you who don't remember the history, was that a lot of Americans were very upset because there were a lot of Americans who did not want people in Peru to die because of an unbalanced trade agreement. So it was civil society in America doing the job that the Peruvian negotiators should have done. So Peru gave in, and it was American civil society that said, we can't accept this. And I hope the negotiators this time will do their job so that we want, but that's one framework. The other one is a broader one, and one I would prefer, which is just to say, look, at these issues we need to maintain flexibility. Trade negotiators are not the people to decide intellectual property or property rights. These are things that ought to be decided by democratic processes involving groups from the health, in the case of intellectual property, we want to have the National Academy of Sciences of all the countries, the National Institutes of Health of all the countries, the scientific community, also the business community, the civil society, the health community. But these are the people who should be at the table when we craft an intellectual property regime that's going to affect the lives of so many people. And that's the way it should be done. So one ought to say there's an agreement, that there ought to be an agreement. And there's an agreement that there ought to be a process, and there's an agreement that there ought to be, in that process, one of the questions is, what is the degree of harmonization is necessary to make this diverse group of countries work together in an effective way? So, again, just let me end by reiterating how important I think the work that you're doing. I think it's important for your country. I think it's important for my country, because what this agreement will be affecting the United States as well as your country. And so I wish I could have more direct influence in the USTR. I've tried, and I will continue to try, and I'm working with, inside the White House and elsewhere. But a lot of it is on your shoulders, and I hope in the next couple of days that you will do the right thing. Thank you. Oh, I'd like to.
If anyone has questions for Professor Stiglitz, please raise your hand and identify yourself.
Yeah, José Luis Cárdenas, I'm also from Chile. I work with the dairy industry. Do you have any specific ideas on measures that could be taken within the TPP to balance the pharmaceutical patent system and to avoid that weak patents are granted by the patent offices?
Yeah, that's actually a very good question. That's the kind of detail that's very difficult to write within a framework of of a set of words. It's difficult enough within any one country with a well-defined legal system. You know, the interesting thing about the patent system in general is how much of it is left up to courts and to common law interpretation. And the reason is precisely it's so difficult to write down, you know, what does it mean by a weak patent and a strong patent? But the point is that that's why there'll be a court interpretation and you need to then revisit it by a discussion. Do we need to make, are we going the wrong way? Do you follow me? Weak patents can really slow innovation for follow-on patents. And if you can get weak patents, there's even an argument that because you can get a weak patent, it means your ambition in research is very small. And so by the time if you do the big innovation, all the parts that go into that have already been captured and you can't do the big innovation. So it really slows down the innovation process. So the idea is an important one, but the question is, how do you write that into language and can you do it in this kind of an agreement? Or is this the kind of thing where you really need to have a constant dialogue going on? That's why, you know, this range of questions that I mentioned, what can be patented? That turned out to be a very, you know, which is one of the other issues in the discussion. The U.S. has changed its mind over this issue over and over again, and you shouldn't, you know, get locked down into a particular view. Should you have business practice patents? A lot of people think that that is stifling. Do you know? I don't know if you know one of where our patent office at one point went wild, that they gave a patent for I forget what letter it was, like the letter X for exit on a computer program, that you could get a patent for that. Or Q, it was Q for quit, that's what it was, Q for quit. And they said that that was patentable. Now that was a, you know, major step forward for the progress of science, knowing that Q might stand for quit. But it took a lot of research, but you can see how that can be a problem. Standards are another thing where, so defining what are the things that can be patented, you know, mathematical algorithms. So there's a increasing view that we've not gotten the balance right. And even the U.S. Supreme Court, I mean, you know, even the U.S. Supreme Court has intimated that the U.S. Patent Office has been going in the direction that there's not a patent application that it doesn't like, and has been circumscribing the patents. It's been saying, you can't patent this. You know, so it's been pulling back on what is patentable. Another issue that turned out to be very important, I was involved in, was a case we have a law that says if you infringe on a patent, you can have your product excluded from coming into the United States. In other words, you cannot import into the United States a product that is infringing on a patent. Well, a very small company called XYZ that had spent $1 million of research, filed a suit against Intel, Apple, HP, arguing that Intel's chips, all the research was done in the United States. The wafers were made in the United States. They were then sent to Asia to be put into chips and then sent back to the United States. They said that infringed their patent. And they wanted to shut down the entire U.S. Industry. All the advanced chips in the United States would be excluded. We would not be able to have any chips. It was really an attempt to shut down our whole industry. It was a blackmail. They thought Intel would pay the blackmail. Intel said no, because if we pay you, there are thousands of other companies out there waiting to make this kind of a suit. And so it went to the International Trade Commission, which adjudicates these disputes. And there is one provision in this law saying that you can override this if it's in the public interest. Now, you would have thought it was obvious that it was in the public interest, that shutting down the computer industry in the United States was not really in the public interest. They've only used this public interest provision 4 times in 40 years. We won on that case too. But the point I want to make is it took a company that, like Intel, with their financial resources, to be able to defend themselves against these suits. If you're a small country and a small company, these suits will come all over the place. So you have to have subtlety in your intellectual property regime. Realize that our intellectual property regime that we're trying to foist on the rest of the world is a very litigation-intensive intellectual property regime. And you have to think about what that will do to the way your firms operate and the way that if you're giants like Samsung and Apple, you can slug it out and spend millions and millions on lawyer fees. But if you're not, it's not an easy life out there.
Other questions? I have a question. So I'm with Activists. We are a hybrid company. We do both brand and generic products. So we're in favor of a balanced agreement, like you mentioned. And my problem is that we have good policy arguments, but when we don't have the political clout or the political formulation right, those policy arguments go nowhere. They're the best policy arguments you can make. So I'm in this conundrum of what do we do about that? I'm looking for your enlightenment here.
Well, what I guess I've always taken the view is the only thing you can do is to just keep pushing forward on what you think are the right policies, using the best arguments that you can use. These are intellectual debates, and you have to think about what are the arguments on the other side. And I've always been a little, impressed that arguments do matter. People do pay attention to the arguments, about whether this is job creation or innovation creation. They try to use arguments. One of the things that often happens is the quality of the evidence in the arguments may not be as good as they would like, or one would like. That is to say, a lot of these areas, getting data is really difficult. And there are asymmetries in who has access to the data. So if you're a drug company, you have more access to drug data than others, and so you can make a claim that others can't easily refute. But that's why there have been so many. It is so interesting that there have been several studies now that have been looking at the effect of, in the drug industry, the effect of these patents on innovation. And several studies have come out in the National Bureau of Economic Research showing that it has that where we've wound up now has a negative effect on innovation, on follow-on innovation. And that should at least say, look at, if it were zero, we should know what our view should be. Access to health is, the only argument for tighter intellectual property rights is that, there's a trade-off between access to medicine on the one hand and innovation on the other. But if the results say that it has a negative effect, then it's a no-brainer of where you want to come out. But again, I guess I want to keep this view on the flexibility. It could turn out that the industry could evolve in ways that these relationships could change. But you don't want to lock in today into a legal trade framework a particular view of the world that can change. Anybody who wants to see what happens when you get locked into a economic agreement based on a particular set of ideologies or ideas, should look at the Eurozone, where they made a monetary arrangement based on a set of ideas that were prevalent in the 90s. And we now know most of those ideas were wrong, but getting out of it has been a nightmare and a depression. So I think the lesson on that is maintain flexibility. And of course, that's really what democracy is about. You have to fight these, go back. You're going to have to fight these fights over and over again. We fought it in the Hatch-Waxman and we got a balance, and then they try to push it one way or the other, and you look at the evidence as it comes in, and you have to re-examine it, and you would have thought today, with the generics in the United States having 87%, 86% of the industry, it would have a louder voice in these negotiations. You would have thought that with Obama so concerned about the cost of health care, he would have put more emphasis on what do we do to promote competition and lower prices. I have an op-ed coming out in the New York Times, I think probably tomorrow, where I say, this is one of the big puzzles, baffling. How could the administration take a signature initiative, Obamacare, one of the intents of which was to lower the cost of health care, and a very significant fraction of those costs are borne by the U.S. government. So that's a signature initiative. And now, in his trade policy, his USTR, which I think is not fully consulted the rest of the administration, is pushing for a set of policies that will raise the cost of medicines and undo at least part of his signature initiative. So, and a reason I wrote it that way is I think that when these contradictions get exposed, it makes it more difficult for them to maintain the position that they are in the trade negotiation. I think his position to try to get healthcare costs down was the right position. It's obviously an inconsistency. Which one do you want to change? Clear, the right one to change is the trade policy. But let me say where the debate in the law and economics profession is today. It's quite strong, at least in America, which quite strong, that we've gone too far. That we need to get what do we say, more balanced intellectual property regime. And so I think this is the broad consensus on the law and economics profession. So to give you a couple of examples, There's a very distinguished professor of intellectual property at Duke called Boyle, Professor Boyle, who has a very evocative term. He calls it the second enclosure movement. You know, those of you who know the history of England and Scotland in particular, there was the enclosure movement where they enclosed the commons in Scotland and gave that property to the lords. And it was, we benefited, and some people in Canada benefited, because it would, they were, the ordinary citizens, workers were pushed off their land, and they had to come to the United States and Canada. So, but it wasn't very nice for them. It was a real period of real travail in these countries. Well, he's written about what he called the second enclosure movement. What we're trying to do is enclose knowledge. And in a way, what he says, this is worse than the original one, because in the case of the original closure movement, you could say there was a trade-off, that there had been overgrazing. That problem was actually not correct, because people could have developed regulations to stop overgrazing, and they actually did that. That would have been an equitable way of doing it. So that was at least the trade-off. They called it the tragedy of the commons. But in the case of knowledge is what we economists call a public good. If one, you know, Thomas Jefferson, our third president, put it, if one candle lights another, it doesn't diminish from the light of the first candle. So knowledge has this distinctive property that you shouldn't enclose it, except if in doing that you can provide more incentives for the creation of more knowledge. That's the only justification. And what they say, so the analytic discussion is that balance. And there is increasing evidence, people like Carl Shapiro, others, that they've talked about that it isn't now, it's gotten to the point where it's actually impeding innovation rather than supporting innovation. And you have the patent trolls, the patent suits, the patent thicket. This is not in your area, but in high tech, you know, in software, just you write a program, you're going to that's successful. Yeah, and you sue, and it's a major problem in shutting down innovation. Some of you may know the most dramatic example of this was BlackBerry. Some of you may have BlackBerry, but BlackBerry got sued for infringing in a patent, and they had to pay a bribe to the company of something like $600 million. They were negotiating and said, look, if it turns out that your patent is invalid, we want some of that money back, because you had to pay the amount before you knew whether the patent was valid, because it was being challenged in court. And the company said no. And BlackBerry was held up for ransom and had to pay the money. So that's an example of unbalance. That's going back. Our court system is trying to constantly readjust it to get a better balance. And that, I mean, I have to say, and the USTR doesn't seem to, and this, at least in my day, and even now, doesn't seem to understand that kind of subtlety and complexity in intellectual property. And that means that there's a risk of locking in a really bad system. But as I say, to go back to your question, the weight right now in the views in American law and economics is that the current legal framework in the United States is not the right one. And that the process of getting it corrected is very difficult because of the conflicting interests that are at the table. But in terms of the academics, there is a broad consensus on that.
Good morning. I'm Noelle Royker from Mylan. I'm a generic company that's US based. And so we have a lot of experience with the American system, and we grew up in the American system. That's how our company got a foothold, is under the American linkage system under Hatch-Waxman. The question I have for you, Professor, is really about this conflation between intellectual property and the exporting of IP standards through trade agreements with the exportation of regulatory regimes, for example, through the patent linkage system that's being proposed under TPP. And the question I have really is, as a company that has a lot of experience with this linkage regime in the US, you know, Hatch-Waxman is, I don't know, hundreds of pages of long. It was in 1984. It took 20 years before it was corrected and vetted and fought in the courts, and then it was corrected in 2003. And now we see, you know, a small paragraph included in TPP that's going to require that complex system to somehow be exported to these markets. And we have grave concerns as a company that this would impede our trade because we don't know how it's going to be implemented. And I have, you know, my question for you today is, how do you see the role of these exporting, not of IP standards, but of very complex regulatory systems through trade agreements?
Yeah. Well, I think, again, that's a good question, and I think that goes back to my point that this is not the right place to be solving these issues. That's why my second view of how you ought to go about that, there ought to be an agreement that we ought to be engaged in a process of of sharing views, but each country has their own legal system. I mean, so it's not only, even if you exported the exact words of the law, when they get adjudicated in different countries, their outcomes are going to be different. I mean, you know, there's a very strong, going back to your question about legal, there's a very strong legal doctrine that people in Columbia Law School about legal transplants don't work. That transplanting a set of laws from one country to another in general doesn't work. Every country has its own history, interpretation of words, let alone problems of translating the words into, but you know, even if English is your language, translate, you know, the context in which you make judgments, in which you evaluate, adjudicate disputes is going to be very different. So the example that is sometimes given of a real failure of legal transplants was after World War II, we imposed on Japan our competition law. Well, it hasn't worked out the same way that it did in the United States. The words may have been exactly the same words, but when you try to transplant those words into another country, the words mean different things. And into a different economic structure, they wind up quite different. So I think, and the problems that are going to arise in each country are going to be different, and the problems are going to change over time. You know, as I said, biologics you didn't have 20 years ago, 10, 15 years ago. So how could you write down a legal standard for biologics? So that if there were a paragraph that I would put in, I would say, let's create a framework of the national science foundations, national academies, national health authorities, to begin to see would identify where are the real problems in our systems. You know, we don't, I mean, my own view is you don't need to have the same language in all countries, the same, you know, we have different laws in the 50 states of the United States. We don't have a uniform legal system. So we've lived with that kind of variation, and we think it's a good thing. So the question is, why in this particular area do you need uniformity? I don't think you do, but you need to talk about where are there things that are causing problems. So rather than beginning with the presumption of uniformity, I would say, let's create a framework that allows us to identify and deal with areas where there are problems, and begin with the presumption of goodwill. You know, presumption that you are a trading community, and if you are a trading community of goodwill, then you want to set up frameworks for working out where things aren't working out well. So that seems to me, you know, and that's the only thing you can do I think you can do in a paragraph. And I think your point about legislation that's 100 pages, you know, long, and then they got it wrong, putting that in implicitly in a trade agreement makes no sense. I mean, you don't have the time, the energy, the resources to do that. And if you did on financial regulation, which is sort of like an investment agreement, Dodd-Frank, how long was that? Probably 1,000 pages. Do you want to put that into a trade agreement? Or do you want to say you could have section 273 of Dodd-Frank, but not 274, and therefore U.S. has to change section 274 of a 1,000-page agreement? I mean, you know, these are complicated issues where we know the politics are not very nice. I mean, that special interests are playing a very big role, and why should you adopt our language where we know that we've compromised in ways that may not have been the right compromise?